So before we get started, as usual, I want to share some housekeeping information with all of you. So because of the number of attendees, we have muted all lines. However, we do encourage you to ask questions and share information with the group. So please use that Q&A function at the bottom of your screen to send us any and all of your questions, and we'll address those questions after our panelists have spoken. And then you can use the chat box for information and resource sharing, and we will capture all of that good information and send it out after the call in our follow-up email. So we are recording this webinar so we can share it later with others. You'll also get that recording as well. So Generate Health is a maternal and child health coalition. We were founded 20 years ago, and our mission is to mobilize the region to advance racial equity in pregnancy outcomes, family well-being, and community health. We see our role in this crisis to convene the maternal and child health community to share information about how people who are pregnant and postpartum are at risk for COVID-19, coordinate resources that respond to the needs of service providers and community members, and identify collective action opportunities. So today we are going to focus on housing equity during a pandemic. The St. Louis region has been historically segregated, with investment concentration in primarily white areas of this region. The Ferguson Commission report has several calls to action related to safe, affordable, and equitable housing, many of which have yet to be met. Additionally, the housing burden placed on families impacted by COVID-19 requires bold and intentional policies, programs, and funding. So today we're going to explore this topic. We have two wonderful panelists. We did have a third panelist, Sam Blue, but he actually had a family health emergency this morning that happened kind of right before this webinar. So he's unable to be on with us today. He wanted me to let you all know that he's really sorry he couldn't make it, but life happens. And we know that very well at Generate Health, and we're rolling with the punches. And we have two fantastic panelists who will be able to give us wonderful information and have a great conversation about this piece. And hopefully at a later webinar, you all can hear from Sam. He's a phenomenal community advocate, a voice for dads, and is extremely involved in his community and very passionate about the work that we do at Generate Health. So I'm hoping that in the later webinar, we'll get to bring him on and you all can hear from him then. But today we have two phenomenal panelists. First, we will hear from Sarah Turner. She's a housing attorney at Legal Services of Eastern Missouri. And then we'll hear from Glenn Burley, who's a community engagement specialist with the Equal Housing and Opportunity Council. So again, questions in the Q&A box, resources in the chat box. We'll get to all those wonderful questions and have a really lively conversation about housing equity in this pandemic. So without further ado, I'm going to hand it over to Sarah to kick us off.
Thanks, Abby, and thank you, Sarah, and everybody else with Generate Health. It is our privilege at Legal Services to have the opportunity to present to your group and to work with you. I actually first engaged with Generate Health and Flourish with the Clinton Peabody crisis, and we are really pleased to have this opportunity in our latest housing crisis with the COVID-19 to educate the community on tenants' rights. So I want to start out with just laying down what are some of the issues that we're seeing that we're anticipating coming down the pipe. First of all, a flood of eviction cases. We have heard private attorneys representing landlords. They've promised, quote, a flood of biblical proportions of eviction actions as the courts reopen. That stems from a few different things. One is that there are cases that judgments for eviction have been entered prior to the stay-at-home orders. And those evictions weren't actually executed on. They were held by the sheriff because the sheriff wasn't serving them. So that is going to start again. There are cases that were filed but not processed prior to the stay-at-home orders, and so those are going to resume. There are cases that were pending at the time that the stay-at-home orders were entered. Those will resume or have resumed. Then there are new cases that are going to be filed by landlords now that the courts are opening again. After July 24th, there are going to be even more cases that could be potentially filed once the CARES Act moratorium on evictions ends. And I'm going to talk about that, the CARES Act and the protections that it afforded. And then there's just all of the newly arising landlord-tenant cases that would have come up regardless of COVID. And so we are just, as I said, expecting a flood of eviction cases. And one of the most concerning aspects of that is that 98.8% of tenants are not represented by an attorney. And adding to that, that when in the city and in the county, when the courts have opened up, they are doing so handling landlord-tenant cases via remote teleconferencing tools like WebEx and Zoom. I'm going to talk a little bit about that as well, which brings about a whole other span of equity issues for our client populations. And in addition, we are seeing that families are having a hard time finding new rental housing, being able to relocate because of a lack of ability to either see homes, or we also anticipate that with these uptick in eviction filings, that with the pending lawsuits, that landlords may be more inclined to reject a prospective tenant. And finally, with regard specifically to subsidized housing, housing authorities have been allowed by HUD to adopt waivers of certain HUD rules and regulations. Some are potentially beneficial to tenants, others could be potentially harmful if not handled properly. So I'd like to talk a bit about that. But you can move to the next slide. First, I want to talk about the CARES Act, and you can advance to the next one. So what the CARES Act is it was passed by Congress in late March, provides certain protections for most tenants in federally subsidized or federally backed housing. And those protections include limits on evictions and fees for not being able to make your rent payments. And the next slide, please. And more specifically, what the CARES Act provides is that from March 27th, when the act was passed, to July 24, which is 120 days, landlords and housing authorities cannot file a legal action to evict tenants for non-payment of rent or other fees or charges. They also cannot impose fees, penalties, or other charges related to non-payment of rent. And they also cannot issue a 30-day notice to vacate or to terminate the lease during this 120-day moratorium. With regard to the notice to vacate, what that also means is that a notice to vacate actually can't be effective until the end of August, because a 30-day notice is required. And if they can't issue it until the end of July, that means that the actual vacate date can't be until the end of August. So if you can advance to the next slide. So the question is, who's protected under the CARES Act? There's a lot of information out there, misinformation going around, people not understanding what this means. And so it's important to understand that the CARES Act protections apply to tenants who receive federal rental assistance or who live in federally subsidized housing, or whose landlord has a federally backed mortgage. Next slide. So examples of what, who those tenants are, what properties are included. Public housing, Section 8 housing choice vouchers, HUD multifamily housing, also known as project-based Section 8, Section 202 housing for the elderly, Section 811 housing, persons with disabilities. There's also Section 236 housing, low-income housing tax credit, and a slew of other federal subsidized rental programs. I haven't listed all of them there. But the other key thing is to know that Rental properties with federally backed mortgages are also covered under the CARES Act. So that could be somebody who, that could be a property or a tenant living in a property who doesn't receive federal rental assistance. It is not a commonly known subsidized property, but it could still be covered if the mortgage is federally backed. You can go to the next slide. So federally backed mortgages, examples of FHA, VA, HUD, USDA mortgages, also including Fannie Mae and Freddie Mac. So how do you know that your landlord has a federally backed mortgage? Well, first of all, that it's limited in terms of the access to that information. There are ways of finding out some of that information. Unfortunately, it is limited to properties that have 5 or more units. There is no, that we have located, no publicly accessible database for federally backed loans on properties that are 1 to 4 unit properties. However, if you go to the next slide, there are mortgage lookup tools for properties that have buildings with 5 or more units. There is a caveat with that in that in these databases, there are some potential data quality problems. It doesn't necessarily include all of the apartment complex or townhome developments, and some of the Fannie and Freddie data can be outdated. However, something's better than nothing. If you can, you can, and I guess the point of this is you can put your address in and maybe you get a hit and it lets you know that there is a federally backed mortgage. However, if the address does not come up, that doesn't necessarily mean that the property is not covered. With the CARES Act, though, and as I had mentioned before, there is this moratorium on filing eviction actions. And we have seen in the city and the county, the courts, the landlord-tenant courts have entered orders requiring landlords to file an affidavit with any rent and possession action that attests to the fact that the CARES Act does not apply to the property. However, Legal Services has identified nearly 60 actions that have been filed in the St. Louis metro area between March 27 and June 3rd that are believed to be actions that would have been prohibited by the CARES Act moratorium, because they are listed in the CARES Act moratorium databases. We also suspect that that's actually an undercount because of the gaps in the database that I had just mentioned. So that is obviously a significant concern. And when you have 98.8% of tenants not being represented by an attorney, we certainly are very concerned that tenants will end up with judgments entered against them that should have been prohibited under the CARES Act. The other important thing to understand is that the CARES Act does not affect lawsuits that were filed before its enactment. So lawsuits that were filed before March 27th. It also does not prevent the filing of eviction actions in non-federally subsidized or federally backed housing. And excuse me. It also does not prohibit evictions based on reasons other than non-payment of rent or non-payment of other fees or charges. So if an action is being filed because the landlord has terminated the lease and the tenant did not vacate the unit prior to the termination date, then what the landlord would do is file what's called an unlawful detainer action. That's not an action for rent. It's an unlawful detainer action because the person had their right to possession of the unit terminated, but they continued to stay. So the CARES Act does not prohibit those types of filings. However, we have seen potential cases in which the landlord may file an unlawful detainer action because they terminated the lease, but the reason the lease was terminated was because of non-payment of rent. And so again, when you have tenants who are largely unrepresented, that do not understand, one, the prohibitions of the CARES Act, or are unable to advocate for themselves and to explain that distinction to the courts, we are concerned about the risk of unlawful judgments for eviction being entered against those tenants. And so I'm just going to stop here and just, I can't emphasize enough, Legal Services of Eastern Missouri is open. We have been open. Our staff is working remotely, but we are working in full force, and we are monitoring all that is going on with COVID-19 and with the CARES Act and with all the changes in the courts. And we are taking new intakes and referrals, and we are representing clients just as we did prior to the stay-at-home orders. And we will continue to do so. And so the most important takeaway I see from this is that we are available and want to hear, and we need to hear from tenants who are facing any of these housing issues so that we can assist them with navigating all of these issues. So one of the things that Legal Services of Eastern Missouri has done in making information accessible to our to the community is we have developed an online tool to help with. I'm sorry, Sarah. Can you advance the slide? So, what is it to help a tenant if they can't pay rent, and to assist them with communicating that to their landlord and letting their landlord know so if that there are potential federal protections for the tenant to perhaps help the landlord to think twice before proceeding with a rent possession action. And so there's a link here, and Sarah, I think if you click on the link, it should work to take you to Legal Services of Eastern Missouri's website that would help a tenant to create a letter to their landlord that communicates their inability to pay rent due to financial hardship relating to COVID-19, and also reminding landlords of federal protections. So it looks like the actual webpage that that would go to doesn't show up in the PowerPoint. So one of those technical things. Oh, there it is. Okay, fantastic. And so you just enter this information in, and then Sarah, if you scroll down a little, you can see that there's the letter that would be generated once you just type in your information and you hit print. So it's a fantastic tool for those who have access to the internet and are able to print it or save it and email it to a landlord. However, if that is not an option, they can simply draft their own letter that communicates that they are unable to pay their rent, that it is related to a financial hardship relating to COVID-19, and stating that for the CARES Act, that they are protected against the filing of a rent and possession action, as well as the imposition of late fees for 120 days, or at least until the end of July. But I would emphasize that rather than simply drafting a letter themselves, that they contact Legal Services of Eastern Missouri, and we could either if there is an issue that they need representation on, we may be able to assist them in that regard. But if not that, to at least help them with navigating our website, this tool, or providing further assistance in drafting a letter to let their landlord know why they're unable to pay their rent. Excuse me. And so we can go to the next slide, Sarah. So lease terminations unrelated to rent, as I had mentioned before, landlords can still issue notices to vacate for reasons other than non-payment of rent. Even if this happens, though, the landlord must go through the judicial process and obtain a court order. Up until May 15th, or excuse me, up until May 18th, the courts had suspended the landlord-tenant proceedings, but they have started to resume those proceedings. One thing that we were very concerned about, though, was during that time that the proceedings were suspended, is that landlords would engage in self-help eviction tactics like changing the locks or shutting off utilities. We can move to the next slide and then the one after that. So it's important to understand what a lawful eviction is. So a landlord who is seeking to evict a tenant must go through the judicial process. And what that means is they must file an eviction lawsuit. It could be a rent and possession action or an unlawful detainer action under Missouri law. They have to file that with the court. Then they have to win in that court proceeding and have the judge issue a judgment for possession of the property. Once that judgment becomes final, which is 10 days after it's entered, they then must request the sheriff execute the judgment. So this is the process that has to be followed in order for a landlord to be able to evict a tenant. Next slide, please, Sarah. So self-help evictions are always illegal. So a lockout, changing the locks, shutting off utilities, removing the tenant's belongings, somehow, some other way of interfering with the tenant's access to the home, boarding up windows and doors. If this happens and the landlord has not obtained a judgment for possession that has been executed by the sheriff, the tenant should call the police immediately and also call Legal Services of Eastern Missouri. We are able to represent tenants who have been illegally locked out and file an action with the court to stop the landlord from doing that. So with regard to the courts, next slide, please. And forgive me for moving so quickly through this. There's a lot of information we're hoping to cover. As I mentioned, the Missouri Supreme Court had suspended all in-person court proceedings through May 15th. They are now reopening. They're doing this as a phased reopening. In the city, St. Louis City Circuit Court and Associate Circuit Court, they are currently in phase 1. And in phase 1, that means that there's a maximum of 10 people allowed in the courtroom at a time. And so for landlord-tenant cases, they are still not holding in-person hearings. And the county is in phase 0, which means that there are no in-person hearings at all. St. Charles County and Jefferson County are both in phase 2. So in-person hearings are being held, but there's a maximum of 25 people in the courtroom. Anybody who is going into court, they have to have their temperature taken. Masks may be required. But in St. Louis City and St. Louis County, where they are not holding in-person hearings in landlord-tenant cases, what they are doing is they have resumed their landlord-tenant docket, but they are doing it by video conferencing. In St. Louis City, it's through a platform called WebEx. In St. Louis County, it's through a platform called Zoom. This is obviously very concerning for legal services and for our clients. in terms of the courts being accessible and people having access to the technology that is needed in order to have any sort of meaningful participation in these landlord-tenant hearings. They have, the courts have said that if a tenant has an issue with technology, that they can't access WebEx or they can't access Zoom, that there would be this call-in option. But the reality is that if a tenant is calling in, they're calling in, so they're calling in to the clerk's phone, presumably. They're put on speaker while the judge and the landlord or the landlord's attorney are having a video conference. And this is not even getting into concerns with trials and access to exhibits. There is a significant equity issue here, and the playing field was already unlevel going into landlord-tenant court for tenants, and now with these hearings or landlord-tenant matters resuming via video conference, we are more concerned than ever about due process issues for tenants. The other concern, or what bolsters that concern, is that the courts have stated that if a defendant or a tenant does not appear when they are required to in the remote hearing, a default judgment could be entered against them. Now we have seen that there are, I've seen one judge who is not holding fast to that for that's the first week that they've opened up. However, we can't say that all judges are going to be lenient, and in fact, judges have said very clearly that default judgments could be entered, and that while they will certainly take some things into consideration, that they are bound by what the law is. So obviously, we're very concerned about that. And again, I just want to reiterate, if we can just get out the message to people that that legal services is available to assist them if they just contact us. And I will be providing contact information at the end of this. So if we can go to the next slide. So for tenants who have received a summons or who already had a pending case, what can they do to find out what is happening in their case? They should go to courts.mo.gov/casenet to look up their case and find out what the court date is. As far as general information about the status of the courts and their reopening, what phase they're in, how to contact the clerk for the division that their case is pending in. We've put up the links to the St. Louis County and St. Louis City Circuit Court websites where they would be able to get contact information, access orders that have been issued by the courts. Abby, how am I doing on time? I don't want to take up too much more time. And
yeah, you're good.
Okay, all right. So I want to be respectful of Glenn's time as well. I know he's got some excellent information to provide. So just briefly here, other issues for tenants. Tenants in subsidized housing. It's important to be aware of some issues, and these aren't the only issues, but just some things that we have seen come up or we want to emphasize. So first of all, income changes. So for tenants who have either suffered a reduction in hours or have been laid off from their employment, in subsidized housing, rent is based on the household income. So if there has been a reduction in income, it is so important to immediately communicate that to either the landlord or the housing authority, depending on what type of property you are in. And project-based Section 8 housing, make sure that you let the landlord or property manager know that you have had a reduction in income. If you're in public housing or a Section 8 voucher holder, make sure that you in public housing, let's make sure you make the property manager aware. If you have a housing choice voucher, make sure that you let your caseworker at the housing authority know. It is so important to document that as well, that you have provided that information to the property manager or the housing authority. So making sure that you put it in an email, or if you can't put it in an email, put it in writing, and then take a picture or a photocopy of what you provided to your caseworker or to the property manager, so that you have documentation that you reported this income change, so that the reduction in your rent is made effective at the time that you have reported the change. Another important thing to know, and this applies to not only subsidized housing, but to private landlords as well. Despite the stay-at-home orders, tenants are still entitled. They have a right to safe, habitable housing. Landlords still have an obligation. Housing authorities still have an obligation to provide habitable housing. That said, the HUD has allowed housing authorities to adopt certain waivers of HUD rules and regulations. Those waivers do not include the obligation to maintain habitable housing. However, those waivers do impact potentially the habitability issues, conditions issues in subsidized housing. Specifically with regard to inspections at Section 8 housing choice voucher properties. So the St. Louis Housing Authority in the city has adopted a waiver that allows landlords to provide a self-certification regarding the condition of the property. And so if a tenant is either looking to move into a new property and the housing authority needs to inspect that to make sure that the home meets housing quality standards, landlords are being permitted to simply self-certify that there are no issues with the home. If there is a complaint inspection requested because there are maintenance issues with the home, St. Louis Housing Authority is allowing landlords to self-certify that either the issue doesn't exist or that it has been fixed. And so it is extremely important for tenants to know that this option I shouldn't even say option, but that this practice is currently in place for landlords to provide self-certification. And so if the housing authority is not taking action to address issues with the property, it may be because the landlord has reported to them that there isn't any issue. And so it's very important for tenants to be communicating with the housing authority and ensuring that the conditions are actually addressed. Another thing to be aware of with regard to complaint inspections is that they are not being conducted for non-emergency maintenance issues. But if there is an emergency issue, such as a gas leak, no running water, there's no air conditioning during times of extreme heat, these are issues that do need to be addressed. And so we have heard from people who have said that their landlord has said, well, because of the stay-at-home orders, they can't come and deal with maintenance issues. That is not accurate. And as I said, they do still have an obligation to maintain habitable housing. On the slide there are a couple of links to the St. Louis City Housing Authority and St. Louis County Housing Authority to get additional information and updates from them about what they're doing in response to this COVID-19 pandemic and what their policies are and when they will be opening their offices back up to the public. So I encourage you to access those links. And finally, just wanting to make everybody aware of another issue that we've seen come up, and that is with a email scam that is impacting Section 8 voucher holders who inquire online about a rental property that they see advertised, and then they subsequently receive an email that is presented as an email from the housing authority, but it is just a generic housing authority email address, and it is asking for information from the tenants. And it is very easy for tenants to believe that this is legitimate email because they were just inquiring about the property online. And so that is something to be aware of. It can take different forms, but one of the primary things that we see is that it is, like I said, is a generic housing authority email. So it's very important to make sure that if you are receiving emails requesting information, that you double check and you follow up with the actual entity that you are dealing with, or actual agency that you're dealing with, to ensure that this is a request from them. So the last slide, a general slide. If you have any questions, food stamps, unemployment benefits, access to healthcare coverage, eviction or landlord-tenant issues, other legal problems that are non-criminal in nature, because we do not handle criminal cases, but any other issues, we are here, we are open, and we just strongly encourage people to call us. And just again, thank you for the opportunity. Oh, I'm sorry, I have one more thing. One last slide. There is a link for additional COVID-19 updates available online at Legal Services website. We have a lot of FAQ and information sheets on the issues listed on the previous slide, and also specifically with regard to landlord-tenant matters, the CARES Act, just a lot of really great information and resources available to people. So just strongly encourage you to check that out as well.
Awesome. Thank you so much, Sarah. That was extremely informative. And I know that I think I saw a bunch of chats coming up, so people are having some conversation around that. So thank you so much for sharing that information. So I'm going to hand it over to you, Glenn, and we'll get some more awesome info, and then we'll do some Q&A.
All righty. Can everybody hear me? Yeah? Okay, good. So my name is Glenn Burley. I am the Community Engagement Specialist for the Metropolitan St. Louis Equal Housing and Opportunity Council. We are the Fair Housing Initiative Program partner for HUD in the St. Louis metropolitan region. So we cover both sides of the river. I often tell people I work from one O'Fallon all the way to the other one. And we also provide some tenants' rights assistance, so we're not nearly as large as legal services. Real quick, I'm going to go over what is covered in the Federal Fair Housing Act, the protected classes, and then we're going to talk a little bit how some of them would interact potentially with parents and other folks. I'm also going to talk some about resources for homeowners. I know, we've had a lot of talk about tenants and stuff today, but it's, not only tenants are losing their jobs right now, right? And, the economic issues that we face are widespread. And, there's a lot of people that, and there's frankly a lot of confusion around what options there are for homeowners. And so I did want to clarify a little bit of that towards the end there. But real quick, let's go over what's in the Fair Housing Act. So the Fair Housing Act, also known as the Civil Rights Act of 1968, has 7 protected classes. It did not initially have 7 protected classes, but there have been additional classes added over the years. So obviously the one that folks most closely identify with the Fair Housing Act is race. Now the Fair Housing Act also covers color as a separate protected class from race. So it covers race and colorism separately within the Fair Housing Act. National origin is another one that we commonly see. So if you're not born in the United States, basically naturalized citizens or native-born citizens should not be treated any differently in a rental situation than somebody that has moved here from another country. Religion, gender, I'm going to get back to that a little bit after this. Disability, and the last one, and one that is very probably pertinent to this audience, is familial status. So real quick, I'm going to go back to gender. So you may have seen some news stories and stuff around sexual harassment of tenants during the COVID crisis. So and this is something that we spend a lot of time trying to educate the public on, which is that when EHOC files a gender case, very seldom is it somebody says, I don't want to rent to men, or I don't want to rent to women. It is almost always a sexual harassment complaint. And this is something that, we try and make sure folks understand that sexual harassment by the landlord or their employees is not annoying, it is illegal. Right? Sexual harassment isn't something that is only illegal at your job. It is also illegal when your landlord attempts to do it. And the reason I bring that up, and the reason why we've seen an uptick in these cases, is that the landlords that tend to engage in these activities do so when they have the opportunity to. And one of the things we most commonly see is landlords that attempt to trade sexual favors for rent or discounts or getting repairs done to tenants' apartments. And specifically, we see a lot of landlords that target single parents. One of the most sort of vulnerable populations in this particular situation, and that we've seen a number of times, is that there are certain landlords that will target single women who have Section 8 vouchers for this activity. And essentially the landlord is getting most of the rent, or at least a portion of the rent, from HUD every month. And what we have a tendency to see is, and again, the landlords that engage in this activity tend to be, predators that this isn't a one-off thing. The type of people that tend to engage in this activity, once we start digging, we find lots of folks. So we had one landlord a few years back where, after we filed the case, by the end of it, there were 16 victims identified over 20 years. And this was for somebody that just had four families, this was not like a big major landlord. But either way, so what will often end up happening is single parents will get in a bind, will offer to trade sex for the tenant's portion of the rent, right? Remember, HUD is paying part of the rent with the voucher, and the tenant's paying the other part of the rent. And the reason we see that this tactic is used so often is because the landlord does get to keep the money from HUD that they're going to get every month, but that the transaction that they present to the tenants, there is no receipt for that. So what ends up happening is that these tenants are essentially get trapped in a situation where landlords can file for eviction at virtually any time because the tenant's portion of that rent is not filed. So I wanted to just take a few minutes to expand on the gender section of the Fair Housing Act to make sure that some of that stuff was clear. Like I said, we, not only us here, but across the country, have seen an uptick in this kind of activity over the last few months. Now, I'm also going to go forward to familial status. Okay, so familial status, I bring this up for this audience especially. Essentially, familial status says as long as two people are related, how they are related, whether it be marriage or blood, doesn't matter, essentially. And that this comes into play with occupancy codes. So what we will often see is, so landlords do discriminate against parents with children, especially single parents, on a regular basis. This is one of our most commonly filed types of cases in the metropolitan region. A lot of times this happens where landlords are essentially telling single parents that, oh, I can't rent you this one bedroom because you would have to sleep with your kid, and we can't have parents and kids in the same bedroom. The reality is that the occupancy code for the majority of units says that for each bedroom there are two people allowed. It's called the heartbeat rule. There are two heartbeats allowed for each bedroom. And what that matters is that it means that landlords, unless it is a very small studio or something where there's only one person for that bedroom, but these are very uncommon, should not treat a single parent with a child any differently than a married couple, right? So that means that if we send in, so a lot of what we do is testing. We essentially secret shopper the landlords, around the area, and we're looking for differential treatment. People being told different things when they go in and apply, and we often see that in this situation where single parents are being told that they can't rent an apartment because of this non-existent rule around kids and the bedroom. Another thing that we will sometimes see, though it's less rare, if your family has another child that would theoretically put you over the occupancy limit for your apartment. So say you have a 2-bedroom apartment, there are 2 adults and there are 2 kids, so that's 4. So that would hit the limit, right? And then another child is born. Sometimes landlords will attempt to preemptively kick families out of their apartments before the end of the lease under the pretense that they are no longer legal, that they are in violation of the occupancy limit because there are now 5 people in the apartment instead of 4. But under the law, that child should not be counted towards occupancy until they are 1 year old. So the law takes into account that, you don't get to plan everything in your life, and that if you have a kid during your lease, you should not be evicted or punished for that. Though you may have to find another apartment, at the end of that lease, right, or in the next year or so, right? But if a landlord attempts to use this as an excuse to cancel your lease or kick you out before it is over, that is not right. And if you are dealing with any of these situations, I ask you to call us at EHOC. Much like legal services, we are still open. We are primarily working remotely at this time, but our landlord-tenant line is still taking calls right now. We are still helping people as issues come in. Like I said, we've been seeing an uptick in things. We've been seeing an uptick in neighbor-on-neighbor harassment in some suburban communities in St. Louis around folks deciding to put Black Lives Matter signs in their yards. So, this is a time of a lot of stress and upheaval, and in my experience, I've worked in housing nonprofits for a long time. I was working in a housing nonprofit, housing related nonprofit in 2008, when the last wave of foreclosures and housing things happened. And one thing that we've seen continually is always the folks at the bottom of the ladder are the ones that tend to get treated the worst in these situations, right? Like Sarah was saying, you know, the majority landlords know that very, very few tenants have an attorney, right? They know that. That's not, you know, if your odds are 98-2 that a tenant's not going to have an attorney, then, you know, you've already know that your power situation is unbalanced in that stuff. And the more likely folks are going to have an attorney, frankly, the wealthier they are, as with pretty much anything in society. But, you know, that's why there are things like legal services, you know, who helps folks that are low income. At EHOC, our funding actually doesn't have income limitations. So regardless of how much money you make, if you're discriminated against in a real estate transaction, we can provide free assistance. So I'm now going to sort of switch veins over to the mortgage side of things for a little bit. I'm going to drop this link in the chat here. So this link, let's see if it pops up. Come on, chat. All right. Good. Okay. So this link is for a unified page at the Consumer Financial Protection Bureau. Now, you know, during this presentation, there have been a lot of random federal agencies that go by various letters that often sound very similar to each other mentioned, right? It's all very confusing. And frankly, what we saw coming out of the gate with the CARES Act was that, you know, that there was a lot of confusion in the general public because they didn't understand many of these things, you know. So you probably didn't get, you know, you didn't go to Freddie Mac to get your mortgage, right, or Fannie Mae to get your mortgage. But because of the way the mortgage market works, between the various federal protections, around 60% of mortgages fall under CARES Act protections and related stuff that has happened around that. And so, you know, we want to make sure that folks know that if you go to this Consumer Financial Protection Bureau thing, what I enjoy about it and I find very useful is that you can just sort of scroll through it, find what pertains to you, and follow the links down to where you need to be to learn and to take steps to be proactive. One thing that I can't stress enough, having also gone again through the 2008 mortgage fiasco, is that the extent to which you as the homeowner or borrower, consumer, are proactive is one of the most important parts of making sure that you get to a good outcome. There are not folks that are trying to help you not send them money. Right? Right? The banks and the servicers and stuff, they want you to send them money, right? And so, you know, that leads to a situation where, you know, that the consumer's interests aren't necessarily the same as the lender or the servicer's interests. And what we've seen in particular is an issue with servicers. And it's kind of, you know, an arcane part about how housing finance works, but most of these loans that are issued are then sold into the secondary market and are serviced. Now, how that's different than if you get a loan from a bank and they hold it on their books. If you get a loan from the bank and they hold it on their books, when you don't pay, they don't owe somebody else money necessarily for that. They're mad that they didn't get their money that month, but that doesn't affect them the same way as a servicer who doesn't actually have the debt. They're simply paid to collect a check every month from you and then send money down the line to the investor who owns that mortgage. So what that means is that unlike a bank, when you don't pay the bank, they just don't get your money. When the servicer doesn't get paid, not only do they not get your money, they're still obligated to pay the investor further down the line. Okay? Like I said, I know this is kind of, esoteric, but it is very important in that most loans are covered by servicers. They're not actually owned by the banks. And we've seen numerous instances where servicers have maybe not misinformed people about what their repayment options are, but have skated around, what those options truly are. And so, and that has to do with their financial situation, right? Again, they have to send money along to the investor, whether or not you send it to them. So it is important to know that if you think that because you filed for a forbearance, you would have to pay back all of the months that you didn't pay at once in a balloon at the end of that, that is not correct. That is not true. If it is covered under these CARES Act rules, if it's one of these Fannie and Freddie mortgages especially. So, and I want to be clear that if your income is steady as a consumer, your best option is to continue paying your mortgage as you have, because that ensures that no extra debt or interest builds up. That being said, if you have had to file for a forbearance because one of the members of your family lost their job or was furloughed or something, that there is what they will refer to as a waterfall of repayment options. So if you file for a forbearance and at the end of that period you can pay back all the missed months, that actually is financially your best option, because it's like you never missed a month, right? That being said, that's unrealistic for a lot of people, okay? And servicers are leading some people to believe that that is the only option. And that then deters people from filing for the forbearance, right? But the reality is at the end of this period, the law allows a couple of different ways for you to deal with modifying your mortgage to fold in those months that you missed. The mortgage could either be modified to slightly increase the monthly payment to keep your payoff schedule on time with your original the original terms of your loan, or some people have the missed months kind of tacked on to the end of their loan. So say you didn't pay for 3 months, your mortgage will now last 30 years in 3 months, essentially. And a lot of this information is on the Consumer Financial Protection Bureau link that I shared in the chat. Like I said, I have yet to find any other webpage that acts as an information clearinghouse in the way that that one does. Because, like I said, there's a whole bunch of different agencies. Many of them's letters are very similar to each other, right? So, like, if you don't speak federalese, it's not the most consumer-friendly thing. But luckily, there's this one page where all the agencies have come together and put stuff down. I think that's probably about all I have. And I'm happy to take questions around lending issues or housing discrimination issues. So yeah.
Great. Thank you so much, Glenn. That is super helpful information. Our chat was kind kind of blowing up. We've got a lot of folks who have work with clients, and so this is really helpful information from both of you. So we've got a few questions. So this one, I think maybe both of you could speak to. There's somebody who's a community health worker who's curious about if it's legal for landlords to enforce evictions during the pandemic. And Sarah, you kind of spoke to this a little bit, maybe perhaps if the proceedings had started for the pandemic, how does that function?
So it depends if my understanding of the question is correct. So for a landlord to enforce the eviction during the pandemic. So going back to what I talked about before about self-help evictions. So a landlord cannot just take it upon themselves to evict somebody. They have to go through the judicial process. And that is filing the lawsuit, number one. So during the pandemic, the courts they weren't shut down. They were still open, but they were operating on essentially a skeleton crew. They are not back to full operation at this point, although they are starting this phased reopening. But with regard to the filing of the lawsuit, so a landlord had to first file the lawsuit to try to evict somebody. So whether or not, that has now been processed or have been pending prior to the stay-at-home orders, I guess is the first question that I would have. Or was the judgment for possession obtained prior to the stay-at-home orders? And if that was the case, well, then again, the sheriff still has to be the one to execute on that judgment. And because sheriffs stopped executing on their judgment with the stay-at-home orders, then again, the landlord cannot take it upon themselves to execute that judgment by doing things like changing the locks. So I don't know if I fully understood the question, but hopefully I have answered it. And I guess really the short answer is no, a landlord cannot enforce an eviction during the pandemic unless they have obtained a court order for possession and they are seeking to enforce that via the sheriff executing, and the sheriff is in fact the one doing the execution.
Awesome, thank you.
And I want to double down on that sheriff part. I mean, that really is it. I mean, we've gotten incredible attempts to evict people. We've had, just crazy stuff. Like one time it was freezing in the middle of winter and the landlord showed up and pulled all the doors off the house and just tried to freeze people out. We had one lady come home and her neighbor across the hallway was throwing all of her stuff in the dumpster because the landlord offered him half off his rent the next month if he'd evict her. Right? So be clear, the sheriff needs to be doing it.
Sheriff. Can't say it enough. That's wild. So there's a few questions about some pretty specific issues about landlords not fixing things, what they will or will not fix. Who can folks contact? Do they reach out to y'all? Can they reach out to you all or with questions about those kinds of things, or who can they reach out to?
So I would say a couple of options. It depends in part on the type of housing it is. So if it is a purely private landlord-tenant situation, and setting aside the whole discussion about the CARES Act and whether it's a federally backed mortgage and all that, totally separate issue. When I'm talking about private landlord-tenant versus subsidized, I'm talking about are you in public housing? Are you in HUD housing? Do you have a voucher? Are you versus the landlord tenant and the rent's not subsidized type situation. So if you are a housing choice voucher holder, you need to contact the housing authority. You need to contact your caseworker. You need to contact the inspections department, and you need to let them know that there are issues with the conditions in the unit that aren't being fixed by the landlord. If it is purely a landlord, private landlord tenant, certainly contact legal services. If there's issues, and Glenn, you can speak to this, if there's issues with perhaps discrimination, whether it's disability discrimination, you have a disability and it's these conditions in the unit aren't being addressed, and that may be an issue, EHOC may be the appropriate place to call. You can contact the health department and report issues with the landlord. Get everything in writing, all of the reporting to the landlord, get in writing, and a question, or not get in writing, but put it in writing that you are notifying the landlord. And I don't want to get too deep into this topic other than to just give a warning. A lot of people believe that if you're having maintenance issues that the landlord's not fixing, that you just get to withhold your rent. And that is not accurate. There are very important requirements that have to be followed. And so if you are considering withholding your rent because the landlord is not fixing things, get legal advice before you just decide to stop paying, because you will find yourself faced with a rent and possession action that is going to do far more harm to you as a tenant than you are harming the landlord by withholding the rent.
And I want to echo some of the stuff Sarah said, especially around doing everything in writing. Tell people, do it by email, do it by text message, just don't do it by phone call. Just don't do it by phone call. We have so many times, our clients come in, I've been calling. Landlord would be like, well, I don't know. I don't remember what we talked about on that phone call. And at the end of the day, I mean, how do you prove that's what you called them about was a repair issue, right? So always do these communications with your landlord via writing, if at all possible, especially because there are parts of the law as far as the landlord's responsibility to make a timely repair that are essentially started by that first communication in writing. And as far as what you would need when dealing with that situation. And as Sarah said, just stopping paying rent is not a good idea. If you are having situations around repairs and stuff, definitely contact some folks at either EHOC or legal services or others. Sometimes it's hard to get things fixed. Sometimes just getting a letter from a law firm on the letterhead gets the bathtub working, or the ceiling replaced in the bathroom. It's a really common one in the city. So, I always definitely recommend people seeking legal help on this stuff. I definitely want to echo the everything in writing piece. But there are issues around disability and stuff that can definitely come into play on this stuff. But one of the reasons we definitely tell people to talk to an attorney is that if things get bad and you have to call to get an inspection, that can be scary for the tenant, right? Like the tenant can be worried about, oh, am I going to get condemned and kicked out of my house if I call in for an inspection? So you want to be as prepared and protected as you can when you're dealing with a landlord that is refusing to make timely repairs, because and this is something, talking about policy going forward with COVID, we are looking at potentially a giant wave of evictions in a few months. Right, the extended unemployment's about to run out, and the economy, while it has bounced back some, it is not fully back. And a lot of folks that are, say, tipped employees and stuff, like even if they're working a shift, they're probably making a half or a third of what they were before this. So they may officially be employed again. That doesn't mean that their income has returned to the same level. And, and this is going to be true with a lot of low wage workers who are folks most, likely to rent, right? So that this crisis really does come down on the renter population in a way that is different than it comes down on the homeowner population. So, EHOC and other groups, there's a group called the St. Louis Housing Defense Collective. We're, trying to work on specific issues such as if we know that there's this giant wave of potential evictions coming, potentially, hopefully it doesn't, but potentially, right? And in a city where most people rent, that's not good for the city's real estate market, right? So like, we're trying to suggest things like a mandatory mediation program where, landlords have to come and at least try and work something out with the tenant before it goes forward to a court case. Right now, EHOC and some others, legal services as well, we do a very limited mediation program where we go to the pro se court, but, we touch a fraction of even the current caseload. So, anything like that can slow down the process, can give the renters another option. Another thing that we've been working, or that we're hoping gets picked up by city officials is, and I think this is, speaks to this group. One thing that we saw in 2008 was that a lot of the programs didn't work. A lot of the programs did not keep people in their homes, but some targeted ones did, to the extent that they were able to. And one of those was a program that went directly through the school districts, so that folks that are getting behind in rent, there was essentially, an emergency fund to help stop people from getting behind in rent and evicted during the school year, which then disrupts the kids, right? Because then the kids got to go somewhere else, right? So, we are encouraging the city and others to look at a similar program that could work through districts and charters and whatnot. And because in a lot of ways, you don't ever want that case against you, no matter what the outcome of it is, right? We tell people all the time that the modern tenant screening softwares and services that people use, the fact that you had a case filed against you, regardless of why, right? It could be that the landlord, that you could see the sunlight through your roof, right? And you decided to stop paying, which again, please don't do that. But like, there are often good reasons that, the tenants, while the law may not be on their side, morality really is, right? And there's some other cases. Anyway, once you've had that case filed against you, very few potential landlords and stuff ever click to see what happened, right? Just that it's on there, even it could have been, one in your favor and all that stuff, but they just don't even look to see how things were, disposed. So, as much as possible, we want to stop people from ever having that case filed against them with some of these emergency rental assistance programs. Because if we only stop it after the case has already happened, that person has probably, their housing options going forward are going to be limited. They will pay more money for worse housing for a long time, even if they didn't do anything wrong, right? So as much as possible, this is a giant worldwide natural disaster, right? As much as possible, we want to try and figure out a way that diverse people from ever going into that court system and getting that case. There's also talk about, going to the the courts, and I'm not an attorney, so I'm not exactly sure how this works, but there was the idea that the judges could change some kind of security clearance so that these kind of cases wouldn't be immediately visible. But either way, our goal, if possible, is that you never get a case filed against you, right? That we keep you in your home, and that your family gets to keep going and doing what you do in your neighborhood, right? Yeah, that's it.
Awesome. Yeah, thank you so much, Glenn. That's super helpful and kind of thinking about some steps moving forward in this. And so we're a little over time, so I want to wrap us up here. I really appreciate you two being here. It's so much information. We will share your info, if that's all right with you two, with everybody to reach out with additional questions. If anybody, there's been a lot of folks who are saying, they're working with families who are having issues that we've been talking about today. So please do not reach out with questions. And we will make sure that you have everyone's information in the follow-up email. So thank you so much, Sarah and Glenn, for taking the time to be here today, providing all this phenomenal information. I also want to thank really quickly my Generate Health team who's working behind the scenes to make all of these webinars a success. And thank you so much to everybody who participated today and all that you all do to care for moms and babies in our community. So as usual, following this call, you can expect to receive a link to this webinar, the compiled information and resources shared, as well as a quick survey. Please don't forget to fill out that survey. It really helps us plan next week's call. And feel free to share that recording and those resources widely. So forward that on to any folks you think could benefit from this information. We will continue to host these webinars as long as they're helpful. We have actually moved to doing them every other week. So please join us, not next Wednesday, but 2 weeks from now, June 24th, same time, same place at 10 a.m. And thank you all so much and stay safe.